West Tennessee, 2017. A state wildlife officer is on the land. He walks out to a tree. He cuts a branch off it and installs a camera on it. The Fourth Amendment does not protect that land. A Tennessee court found the state constitution does. Nobody tells the man who farms the 93 acres. Nobody has to. The man is Hunter Hollingsworth. His land runs to approximately 93 acres crossing Benton and Henry counties. He and his guests use it for fishing, farming, camping, and hunting. It is landlocked. He reaches it through his neighbor's private gravel drive and gate, then through a chain gate of his own, with a no trespassing sign on it. That gate is not the line. A chain gate is what a landowner believes makes entry unlawful. It is not what the law was measuring. The law draws a narrow ring around a house and calls it the curtilage. Outside that ring, the land is what the law calls an open field. On 93 acres, almost all of the 93 is outside the ring. There is a second farm and a second man. Terry Rainwaters works his land in Tennessee too, behind chained gates and no trespassing signs of his own. Two men who go to their own ground less than they used to. Rainwaters has curtailed some of his usage, as he has become hesitant to use his properties or invite guests due to fear of surveillance and fear of injuring a TWRA officer. He testified that he felt exposed as a result of a loss of privacy on his land. Hollingsworth also uses the property to spend time alone with his girlfriend. He fears that officers might be observing him, his girlfriend, or his guests in their private activities, and he has reduced his visits to his land, where he previously more regularly camped and fished. On Rainwater's land, there is a rule about people. As a safety precaution, Mr. Rainwaters and his guests follow a rule that hunters should know the location of everyone else on the property. Everyone on it is supposed to know where everyone else is standing. That is the kind of place it is. On 3 occasions in 2017, Kevin Hoofman, an officer of the Tennessee Wildlife Resources Agency, entered onto Mr. Rainwater's Harmon Creek property to investigate suspected hunting violations. While on the property, Officer Hoofman took photographs. Officer Hoofman entered Mr. Hollingsworth's property on December 21, 2016 to investigate deer baiting, and he took photographs. Officer Hoofman installed a camera owned by the United States Fish and Wildlife Service on a tree on Mr. Hollingsworth's property on November 30, 2017, cutting a branch to do so. A camera belonging to the same federal service went onto Rainwater's property that same November and came off it in December. Whether those installations were the work of federal authorities alone or of federal and state authorities together, the parties dispute. Nobody has decided it. In December 2017, Officer Hoofman entered Mr. Hollingsworth's property and searched his vehicle, and subsequently recorded video footage of Mr. Hollingsworth. Those are the entries that ended up inside a document. How many there were altogether is a different question. The agency does not create records of all of its agents' entries onto private property and does not provide notice to property owners. Officers enter private property, sometimes conceal themselves thereupon, and look for violations of wildlife laws. Sometimes conceal themselves. There are more cases like this one on the channel already, and there are more coming. If you want them, subscribe. If a camera went up on your land today, strapped to a tree, lens pointed at your field, how long before you found it? Notice is the thing most owners assume exists. A knock at the house, a card left in the door, a letter afterwards saying somebody had been out. The law requires none of that. There is a method for choosing which farm to walk onto. In determining which properties to enter to investigate suspected violations of hunting laws, officers sometimes rely on having previously seen hunters on the property, on word of mouth, or on listening for shots. Word of mouth and the sound of a shot carrying over a tree line. Those are the criteria. Officers also enter upon and cross property not under investigation to reach land they intend to investigate. A man's land can be crossed because of where somebody else was standing. There is no ceiling on any of it. The agency does not impose constraints on how often a parcel is entered, what time of day an entry may be made, or how long an officer may remain on private property, and it does not have written policies for officers to follow when deciding whether to enter private property. So the number does not exist anywhere. The agency does not know how many times its agents have entered upon their properties, Nor do Messrs. Rainwaters and Hollingsworth know how many times their properties were entered upon. Neither side of this case can count it. The number was never written down. The two men sued in the circuit court for Benton County in front of a panel of 3 judges. The 93 acres with the tree on them are Hollingsworth's. The defendants were the agency itself, Bobby Wilson, Ed Carter, and Officer Hoofman. The agency's answer was a claim of power. Its officers had the statutory authority to go upon any property outside of buildings, posted or otherwise, in the performance of their duties to enforce wildlife laws. That is the agency describing the statute. The opinion that came out of the case never prints the statute itself. They sued under Article 1, Section 7 of the Tennessee Constitution. The text they sued under names 4 things a person is secure in: persons, houses, papers, and possessions. One word in that list is not in the federal one. The 4th Amendment says effects. Tennessee wrote possessions. It wrote its first constitution in 1796 and did not take the federal word. In 1834, it wrote a new constitution and kept possessions. In 1870, it wrote another one and kept it again. 3 constitutions and 3 times the state declined the federal word. In 1926, in a case called Welch, Tennessee's Supreme Court said why that mattered. The word possessions was added for a purpose. It refers to property, real or personal, actually possessed or occupied. Welch drew its own limit in the same case. It would not include wild or waste lands or other lands that were unoccupied. By 1926 then, Tennessee's own highest court had said the extra word was deliberate, had said what it covered, and had said what it did not. Tennessee has a robust history of protecting land outside the curtilage of a home as a possession under Article 1, Section 7 of the state constitution. The federal charter has nothing to say about that ground. The state charter has 1 extra noun in it. So the state had to say what it was doing on the land, and it did in 1 sentence. Officers enter private property only when, and only in areas where, they believe hunting activity is taking place or has taken place. It is a narrow claim, and it is the agency's. On its account, officers go where they think hunting is happening and nowhere else. It is undisputed that the TWRA believes TWRA officers have lawful authority to enter private property without consent or a warrant to enforce Tennessee's wildlife laws in the performance of their duties. The agency insists that its actions are constitutional. Officers have entered the private property of others pursuant to this purported statutory authority and without consent or a warrant since the filing of this case. And not only the land of hunters, the agency enters upon the property of non-hunters as part of its enforcement activities. There is one more fact about Hollingsworth in the opinion. Mr. Hollingsworth's hunting license was suspended for 3 years in November 2018 due to a federal dove baiting offense. The suspension came in November 2018. The entry he sued over was December 21, 2016. The entry came 23 months earlier. That is where the record on these 2 men stops. The opinion gives no ages, no occupations, and no account of how the case began or why either man brought it. 2 men appear inside a public document for the length of a lawsuit, and what survives of them afterwards is a list of parcels. Terry Rainwaters owns a 136-acre home property with 2 homes on it, farmed in a regular and conspicuous manner. A private gravel path reaches it behind a chained gate with no trespassing signs. He has 69 acres on Liberty Road, fenced all the way around and accessible through a chained gate with no trespassing signs. 2 parcels with an acreage each. That is the whole of him inside the document. Against that, the rule of law being applied is 1 line long. Warrantless searches and seizures are presumptively unreasonable. Presumptively unreasonable puts the burden on the state, and the state discharges it by naming a recognized exception and fitting the facts to it. The agency invoked none of them. It has not endeavored to defend its searches based upon any of the established exceptions to the warrant requirement. An implied consent theory it had raised earlier was held waived. In place of an exception, it offered reasonableness. The agency said at oral argument what a man is supposed to do. If the plaintiffs wish to avoid re-entry by the TWRA upon their properties, they should desist in hunting thereupon. On May 9, 2024, the Tennessee Court of Appeals answered. Judge Jeffrey Oostman wrote the opinion. Judges Arnold Golden and Kenny Armstrong joined it. 3 judges, no dissent. The answer is 2 sentences long. We conclude the statute is facially constitutional but unconstitutional as applied. We affirm the award of nominal damages. 2 questions were in front of them, and they are not the same question. Is the statute unconstitutional as written? And is it unconstitutional as it was used on these 2 men? The first one has a hard standard. The challenger must establish that no set of circumstances exist under which the act would be valid. The statute has to fail in every application it has, and not merely in most of them. And the plaintiffs had already conceded 1 application. They do not dispute that the statute authorizes entries upon wild wasteland areas, or that such entries are constitutional under the Tennessee Constitution. Wild wasteland is outside Article 1, Section 7. Welch said so in 1926. So there is at least 1 lawful use of the statute, and 1 is enough to end a facial challenge. The statute is facially constitutional because there are applications of the statute that are constitutionally permissible. The trial panel had held the opposite. That holding was reversed. There was a second reason. The statute does work. Without it, an officer stepping onto a farm would be committing criminal trespass under Tennessee law. A person commits criminal trespass if the person enters or remains on property, or any portion of property, without the consent of the owner. That is half the opinion, and the state has won it. Then the second question, and the ground changes under it. Their lands were secured by gates, accessible only through private drives, and posted with no trespassing signs intended to limit access to them. The plaintiffs used and occupied their land by farming, fishing, camping, and hunting. The agency's reply was that 3 of those 4 uses are hobbies. While the TWRA endeavors to dismiss hunting, fishing, and camping upon one's property as recreational in nature, such activities, recreational though they may be, constitute actual use of the property. Which brings back the 1926 line and turns it over. These were not wild or wastelands outside the shield of Article 1, Section 7 of the Tennessee Constitution, but instead possessions subject to constitutional protection. So the land was protected. What made the entries unreasonable was the way the decision to enter got made. Article 1, Section 7 runs to a single sentence, and its second half names the thing it was written against. That the people shall be secure in their persons, houses, papers, and possessions from unreasonable searches and seizures, and that general warrants whereby an officer may be commanded to search suspected places without evidence of the fact committed, or to seize any person or persons not named, whose offenses are not particularly described and supported by evidence, are dangerous to liberty and ought not to be granted. Each agent is empowered with the discretionary authority to determine for himself or herself if there is a reasonable basis to suspect hunting activities are occurring on the property. And nothing checks it afterwards. There is no clear system of judicial review that allows consideration of the TWRA's entries upon private property or their agent's comportment thereupon. A warrant puts a judge in front of an entry. Review puts one behind it. Here there is one officer, deciding alone, with nothing written down. The opinion reaches for a comparison. The TWRA searches which it claims are reasonable bear a marked resemblance to the arbitrary, discretionary entries of customs officials more than 2 centuries ago in colonial Boston. Colonial Boston, given the purpose of Article 1, Section 7 of preventing arbitrary intrusions upon privacy and personal liberty, what the TWRA claims is reasonable is not. Subsections 1 and 7 of Section 70-1305 are unconstitutional as applied. And in a footnote, one more thing the agency never explained. It does not articulate why reasonable suspicion rather than probable cause is the appropriate standard. So what did the 2 men get? An injunction was denied below, and they did not appeal that denial, so it was never examined. We do not review the trial court's denial of injunctive relief. What was affirmed was the award made at trial. Plaintiffs are awarded $1 in nominal damages for their constitutional injury, which defendant Carter is ordered to pay. $1. The state had argued that sovereign immunity barred even that. It raised the argument for the first time on appeal. We conclude this argument is waived. The statute is still in the Tennessee Code. On its face, it is constitutional. What the two men hold is a declaration about their own land and $1. Clearfield County, Pennsylvania, July 21, 2026. We conclude that the original meaning of the term possessions as used in Article 1, Section 8, unlike the term effects as used in the Fourth Amendment, includes land. We hereby overrule Russo. That is the Supreme Court of Pennsylvania deciding under Article 1, Section 8 of the Pennsylvania Constitution. The opinion opens on the law it is about to change. Open fields are afforded no constitutional protection from warrantless searches and seizure under the Fourth Amendment to the United States Constitution. The plaintiffs are two private member-owned hunting clubs that own 4,400 acres and 1,100 acres of contiguous land in Clearfield County, Pennsylvania. The record's phrase for what the membership buys, a private place, a sanctuary, where they can come to escape from the hustle and bustle of daily life. On their own ground, members can easily find spots where strangers will not unexpectedly walk in and spook nearby wildlife or accidentally step into their line of fire. One line records what is said out there: family matters, marital problems, work stressors, romantic feelings, and faith in God. That is all of it this account will use. The opinion names no member, a list of subjects with no person attached to any of them. What they did to keep people out is recorded. They have posted their property's boundary lines with clearly visible no trespassing signs in purple paint, installed locked gates at all public entrances, and fenced some of their property's boundaries with waist-high metal wire, all in an effort to exclude non-members and intruders therefrom. Purple paint is a posting method the state wrote into its own trespass law. Pennsylvania landowners, except those in Philadelphia and Allegheny counties, have the option to use purple paint rather than no trespassing signs to post their properties. Mark Gritzer works as a game warden for the commission and is assigned to the district in which the hunting club's land is located. He is a defendant in his official capacity. Since 2013, Warden Gritzer and other commission officers have entered the hunting club's land without consent, a warrant, or probable cause at least 15 to 22 times to look for evidence of hunting offenses. Warden Gritzer even placed a trail camera on Punxsutawney's property in an attempt to develop probable cause for charges of illegal elk feeding. That camera remained on Punxsutawney's property for 78 days. On some occasions, Warden Gritzer has cited individuals for violations of the code. His authority was two provisions of the Game and Wildlife Code, and both of them let an officer go upon land outside of buildings, posted or otherwise. The sign is named in the statute, and it is named in order to be disregarded. Pennsylvania had tested this once before, in 2007 in Russo. A bear was killed on private wooded land in Wyoming County approximately 9 minutes after the opening of Pennsylvania's bear hunting season. Several commission officers entered Russo's property, which was posted with no trespassing signs, without a warrant, and found several large piles of apple mash as well as a corn feeder close to Russo's cabin. The entry was upheld. Chief Justice Cappy authored a dissenting opinion, which then Justice Baer and Justice Baldwin joined. He would have held Section 901A(2) unconstitutional to the extent that it authorizes entry onto posted private property without any level of suspicion of illegal activity. That dissent lost, and it is why the clubs lost in 2023. On September 29, 2023, the Commonwealth Court, sitting en banc, concluded that it was bound by this court's decision in Russo and entered judgment for the commission and for Warden Gritzer. Judge McCullough, joined by Judge Wallace, wrote separately to say she agreed with Chief Justice Cappy's dissent. The case reached Pennsylvania's Supreme Court from there. Russo is only a little over 18 years old, and no Pennsylvania court has applied Russo's holding in a published decision. The majority's verdict on its own precedent, its reasoning and result have not aged well. Slavish adherence to our decision in Russo must give way to the greater privacy and property protections afforded under Article 1, Section 8 of our state charter. Then the rule that replaces it. The scope of the protection afforded under Article 1, Section 8 to a landowner's open fields extends to private land located beyond the curtilage over which the landowner has demonstrated a reasonable and legitimate expectation of privacy by taking sufficient steps to exclude intruders therefrom. Both entry provisions fell. We hold that stare decisis does not compel our adherence to Russo, that Russo was wrongly decided, and that sections 303C and 901A2 of the Code violate Article 1, Section 8 of the Pennsylvania Constitution, not as applied to these two clubs. On their face, we cannot contemplate any circumstance under which sections 303C and 901A2 would be valid under our decision today. Severance was considered and refused. There does not appear to be any invalid language that we can sever, and that would yield operative and constitutional text consistent with the legislative intent behind the enactment of these provisions of the Code. Accordingly, the provisions fall in their entirety. The order below was reversed and nothing was sent back. Striking the two sections had already given the clubs the declaratory and injunctive relief that they sought. 7 justices heard it. 4 joined the lead opinion. Chief Justice Todd filed a concurring and dissenting opinion, and Justice Weck filed a concurring and dissenting opinion in which Justice McCaffrey joined. Concurring and dissenting is a label of its own. One thing did not move. We therefore do not discuss and/or question the federal open fields doctrine further. The federal doctrine stands where it stood. This ruling rests on a state constitution, and it reaches as far as that constitution reaches. Inside Pennsylvania, the opinion lists what officers may still do. The Commission's officers will still be permitted to conduct warrantless searches of private property that is not posted, fenced, or otherwise marked to exclude intruders, to observe evidence of code violations that occur in plain view on private property that is posted, fenced, or otherwise marked to exclude intruders, to obtain a warrant to search private property that is posted, fenced, or otherwise marked to exclude intruders based upon their receipt of information that a code violation has occurred, and to apply a recognized exception to the warrant requirement as a means to search private property that is posted, fenced, or otherwise marked to exclude intruders. Justice Donahue joined the majority and wrote separately, "Today's decision does not preclude administrative searches conducted pursuant to an appropriate statutory framework incorporating the limitations placed on administrative searches." The same opinion noted that in its briefing, the Game Commission appears to confuse the open fields doctrine with the administrative search exception. The administrative inspection provision was challenged too, and it survived. We are not declaring that section constitutional, although it is presumptively so until a court decides otherwise. And the state's Environmental Rights Amendment was not weakened by any of it. This is not a diminution of the importance of our citizens' right to the conservation, maintenance, and protection of wildlife. Pennsylvania limited its own reach in the footnote that reserved the question. We cannot ignore that this case is about rural, undeveloped land, not a suburban 1-acre plot or a 9-acre tract of land upon 1 acre in the center of which sits a swimming pool. There may be ways by which the owners of those latter 2 properties can demonstrate a reasonable and legitimate expectation of privacy that does not involve marking the boundaries of their properties with no trespassing signs or purple paint. We resolve only the question of whether the hunting clubs here have done so. Truly open fields, that is private land that is unposted and unbounded, is fundamentally different in kind than private land conspicuously posted with no trespassing signs and purple paint and/or bounded by fences, gates, and other structures. Government officials, therefore, must obtain a warrant based upon probable cause or satisfy one of the recognized exceptions to the warrant requirement before entering the private land of any landowner that has taken such steps. And then, in that footnote, we reserve for another day the question of whether the privacy protections afforded by Article 1, Section 8 extend to landowners who have taken fewer steps than the hunting clubs, or even no steps, to exclude intruders from their properties. The 1926 boundary had the same shape. Welch put outside the word possessions any wild or wastelands or other lands that were unoccupied. What put these 2 farms inside it in 2024 was gates, private drives, posted signs, and the fact that the land was used and occupied. The branch, the camera, the vehicle search, and the video are all in the record. None of it was on appeal. What the parties put in front of the appellate judges for Hollingsworth was one entry on one day in December 2016. And whether the cameras were state work or federal work has never been decided by anybody. What the two Tennessee men hold is a declaration that the statute was unconstitutional as applied to them, no injunction, and $1. The statute is facially constitutional, and it is still on the books. What the two Pennsylvania clubs hold is two provisions struck from the code, no remand, and the relief they asked for granted where they stood. Each ruling stops at its own state line, and each leaves the Fourth Amendment exactly where it found it. If this changed how you see where the line runs on your own land, leave a like. Wildlife is what both of these records are filed under. What both are about is a boundary where a person's private ground begins for the purpose of a search, and who gets to decide it. The conduct was the same in both states, and it met two constitutions and two answers. The Pennsylvania opinion does not mention the Tennessee case. In one state, a chain and a sign bought a declaration and nothing to enforce it with. In the other, a chain and a sign and a band of purple paint took two entry provisions out of a statute book. Neither answer travels. A man standing on his own field is protected, or he is not, according to which side of a state line he is standing on, and according to what he was able to put up around it. What they did in both states was give an owner something to point at afterwards, an object a judge could look at and call sufficient or not. And the side that won wrote down what it had not decided. It described the landowners in front of it, posted, painted, fenced, gated, and then set aside for another day the ones who had done less than that, or nothing at all,